The day my half-brother filed the petition, I was sitting in my car in the parking garage of the Fulton County Courthouse, hands on the wheel, engine off. I had been there for 11 minutes. I wasn't crying. I wasn't shaking. I was counting the concrete pillars in front of me, one by one, because if I stopped counting, I would have to feel everything I had spent 8 months refusing to feel. I got out of the car, I straightened my blazer, I walked inside. My name is Claire Whitfield. I'm 31 years old. I'm a contracts attorney at a mid-sized firm in Atlanta, Georgia. And on that Tuesday morning in March, my half-brother Marcus stood in a courtroom and told a judge that I had fabricated a dead man's wishes to steal what wasn't mine. The dead man was my father. Let me take you back to the beginning, because none of this makes sense without it. My father, Robert Whitfield, married my mother straight out of college. They had me when they were 26. By the time I was 7, my mother was gone, not dead, just gone. She left on a Thursday. My father never spoke badly about her, not once, and I respected him endlessly for that. He raised me alone in our house in Decatur, just outside Atlanta. He coached my soccer team, learned to braid hair from YouTube tutorials, showed up to every single thing I ever did. When I was 12, he met Sandra. Sandra Whitfield, she took his name fast, was 41, polished, and very good at being exactly what someone wanted her to be when it mattered. She had a son from her first marriage, Marcus. He was 17 when we met, already away at college most of the year, so our paths crossed rarely and briefly. He shook my hand the first Christmas he came home. Firm grip, cool eyes. He called my father sir, and my father loved that. My father loved a lot of things about Sandra's family that I could never quite see myself. I want to be fair here. For the first few years, nothing was obviously wrong. Sandra kept the house, hosted dinner parties, remembered birthdays. My father built his contracting business into something real Whitfield construction, mostly commercial projects across the metro area. He worked hard. He was tired. He was grateful to have someone managing the rest of his life, and I understood that even when I didn't like it. What I noticed, slowly, was the way decisions shifted. By the time I was in law school at Emory, my father was signing things Sandra put in front of him without reading them thoroughly. I saw it happen once at dinner. She slid a document across the table, and he reached for the pen before she finished explaining it. I asked what it was. She smiled at me. He said it was nothing, just paperwork. I let it go. I should not have let it go. My father was diagnosed with early-stage Parkinson's disease when I was 27. He told me himself, on the phone, voice steady, like he was telling me about a weather forecast. He said he wasn't scared. He said he had things in order. He said Sandra and Marcus were going to help manage some of the business logistics while he focused on staying healthy, and that I should focus on my career and not worry. I worried. I started paying closer attention. Not obsessively, I had a full caseload, a life, a small apartment in Midtown, but I started asking questions when I visited. How was the business doing? What accounts were being managed, and by whom? Whether his estate attorney had reviewed anything recently. My father answered some questions and deflected others. Sandra answered fewer and deflected more. Marcus, by this point, had moved back to Atlanta. He'd had a marketing career that stalled somewhere in his late 20s and reinvented himself as a business consultant. His primary client, as far as I could tell, was his mother. He had an office in the same building as Whitfield Construction and a title Director of Operations that my father had given him without ever mentioning it to me. I am not a suspicious person by nature. I am a careful one. There's a difference. My father passed away on a Saturday morning in September. He was 63 years old. I was with him. Sandra was in the hallway. Marcus was parking the car. My father held my hand and he said, "Claire, Bear." That was his name for me since I was small. "You're going to be fine." And then he was gone. I cried for 3 days in my apartment and did not speak to anyone. On the 4th day, Sandra called to tell me the estate would be going through probate and that the attorney handling it was someone named Gerald Potts, whom I had never heard my father mention. I asked for the firm name. She gave it to me. I looked it up. Gerald Potts had been licensed for 6 years, and his practice was a single attorney office in Marietta. My father's original estate attorney was a senior partner at one of the most established firms in Atlanta. That was the first real alarm. I contacted my father's original attorney, a woman named Patricia Hale, the following week. What she told me in that phone call changed everything. 6 weeks before my father died, someone had filed an amendment to his will. The amendment had been executed with a different notary at a different firm, and it significantly restructured the distribution of the estate. Under the original will, which Patricia had drafted 4 years earlier, The business and the primary assets were divided. A substantial portion to me, a portion to Sandra with specific conditions attached, and a trust for ongoing charitable contributions my father had always made to a youth construction apprenticeship program in Southwest Atlanta. Under the amendment, Sandra received full controlling interest in the business and the primary residence. I received a single lump sum payment generous on paper, but a fraction of the estate's actual value, and the charitable trust was eliminated entirely. Patricia told me she had not been contacted about any amendment. She had not been consulted. She hadn't known until she saw the filed documents. My father had Parkinson's disease and was on significant medication in the final weeks of his life. His handwriting on that amendment was not the handwriting I had seen on birthday cards, Christmas checks, documents he'd signed in my presence for 31 years. I did not tell Sandra what I knew. I did not tell Marcus. I did not call anyone except my own malpractice and estate colleague at my firm, a meticulous man named David Park, who agreed to look at everything I had with fresh eyes. Then I started building. I want you to understand what 8 months of building looks like from the inside. It looks like staying late after your actual work is done, pulling financial records your father's business accountant quietly shared with you because he also thought something was wrong. It looks like flying to Marietta on a Saturday to sit outside the notary's office and photograph the signage, then cross-referencing the notary's commission number against Georgia's public licensing database. It looks like finding that the notary's commission had lapsed 14 days before the amendment was supposedly executed. Let me say that again. The notary who certified my father's signature on the document that rewrote his estate had a commission that had expired 2 weeks before the document was dated. A notarized document executed by a lapsed notary is not valid under Georgia law. It is not a minor technicality, it is a fundamental defect. But I kept going, because a defective notarization alone could be explained away as an administrative error. I needed more. What I found more of was wire transfers. My father's business had 3 operating accounts. In the 14 months before his death, as his Parkinson's progressed and Marcus took on the director of operations role, there were 47 transfers to an LLC called Harlan Bridge Consulting. Harlan Bridge Consulting had been incorporated in Georgia 11 months earlier. Its registered agent was Marcus's home address. Its sole member, according to the Articles of Incorporation, was a name I had to read 3 times: Sandra Whitfield. 47 transfers, just under $800,000 in total. Not a salary, not a vendor contract, not anything filed with the business's outside accountant, who had been quietly managed out of his engagement 6 months into Marcus's tenure and replaced with a bookkeeping service that Sandra had chosen. I printed everything. I organized it into binders. I had David review it and then had a second attorney review it after David, someone who specialized in financial elder abuse cases. She looked at my binders for 2 hours, looked up at me and said, "Claire, this is one of the cleaner cases I've seen." I filed the will contest in February. I will never forget Sandra's face when she was served. I was not there to see it, but Marcus called me 40 minutes later, and his voice was something I had not heard from him before, not quite angry, not quite afraid. Something between, "You need to stop this," he said. "Good morning, Marcus," I said. "You're going to embarrass this family. Dad wouldn't want this." "Then I guess we'll let the court figure out what Dad wanted." He hung up. 3 days later, I received a counterfiling. Sandra and Marcus, through their attorney, a large firm, well-funded, which told me they had been anticipating something alleged that I had been estranged from my father in his final year, that I had exerted undue influence over him in earlier years to secure a favorable will, and that the amendment represented his true and settled wishes. They attached a letter, purportedly written by my father, describing his disappointment in me and his decision to restructure his estate accordingly. I had never seen that letter. I had never seen any indication of its existence. My father and I had spoken on the phone 11 days before he died. He asked me to bring him peach ice cream when I visited that weekend. He told me he loved me. I gave the letter to a forensic document examiner. Her report came back in 6 weeks. The ink composition was inconsistent with the pen types my father habitually used, which I had preserved along with other handwriting samples from cards and documents over the years. The letter's paper stock was a brand my father had never purchased, according to the 3-year history of his Amazon account, which his accountant had access to and shared with me, legally and with appropriate authorization. The signature's pen pressure and letter spacing deviated significantly from authenticated samples across an 11-year range. It was not my father's letter. The morning of the hearing, I arrived early. I sat at the plaintiff's table with David beside me and 2 bankers' boxes of organized evidence on a cart behind us. Sandra arrived in a charcoal suit with a pearl necklace. Marcus wore a tie. I recognized my father had given it to him for Christmas 3 years ago. He wore my father's tie to contest my father's will, and I had to look at the wall for a moment. Sandra's attorney, a man named Clifford Burke, opened by painting me as a grieving daughter whose grief had curdled into obsession. He said I had manufactured a conspiracy because I could not accept that my father had, over time, come to rely more heavily on the family members who had been present for his daily needs. He was smooth. He was experienced. He had clearly done this before. Then he called their first witness. Her name was Deborah Finch, and she was introduced as a handwriting expert. She testified that the letter attributed to my father showed consistent characteristics with his authenticated writing, and that the variations I had pointed to were within normal range for a person experiencing the motor effects of Parkinson's disease. I wrote one word on the notepad in front of me: credentials. David cross-examined her. It took 4 minutes to establish that Deborah Finch held a certification from an organization that had been flagged by multiple federal courts for issuing credentials without adequate standardized testing. She had testified in 9 cases. She had been excluded as an expert in 3 of them. In 2 of those 3, the exclusion was on Daubert grounds, meaning the court found her methodology scientifically unreliable. She stepped down. Burke called his second witness. This was the one I had been waiting for. The notary's name was Phil Greer. He was 44 years old, lived in Smyrna, and had worked as a mobile notary for 11 years. He took the stand and testified, with confidence, that he remembered notarizing Robert Whitfield's signature on the estate amendment. He described my father as mentally alert and fully engaged. He said there was nothing that gave him pause. David stood up for cross-examination. "Mr. Greer," he said, "on what date do you claim to have notarized the document in question?" Greer gave the date on the document. "And your notarial commission, can you tell the court when that commission was valid through?" Greer paused, a small pause, the kind that fills a room. "I'd have to check the exact date." David handed him a certified document from the Georgia Superior Court Clerks Cooperative Authority. "This is the official record of your notarial commission. Would you agree that it shows your commission expired 14 days before the date you just gave this court?" The pause this time was not small. Burke objected. The judge, the Honorable Raymond Osei, a man in his late 50s who had said almost nothing for the first hour of proceedings, looked at the document. He took off his glasses. He set them on the bench in front of him and looked at Phil Greer with an expression I will not soon forget. "Mr. Greer," Judge Osei said, "you've testified under oath that you performed a notarial act. The record suggests your commission had lapsed at that time. Do you understand that performing notarial acts on an expired commission is a criminal offense under Georgia law, and that testifying falsely about having done so compounds that significantly?" Phil Greer looked at Burke. Burke did not look back at him. "I'd like to consult with an attorney," Greer said. Judge Osei recessed for 20 minutes. When we resumed, David submitted the full financial analysis, the 47 transfers to Harlan Bridge Consulting, the incorporation documents, Marcus's home address as registered agent, Sandra's name as sole member, the timeline overlaid against the progression of my father's illness and the departure of his longtime accountant, the replacement bookkeeping services invoices, which listed a contact email that traced back to a domain registered by Marcus. Burke tried to reframe. He said the transfers were legitimate consulting fees for services Marcus and Sandra had provided to the business. David asked for the contracts. Burke said they were verbal agreements. David asked for any documentation emails, invoices, meeting notes, anything that would support the existence of an actual consulting engagement. Burke said they were compiling those materials. David said we had subpoenaed the business's email server 3 months earlier and found no record of any communication outlining the scope, terms, or deliverables of any such engagement. Sandra turned and said something quietly to Burke. He put his hand up slightly, the way attorneys do when they need a client to stop talking. Then David submitted the forensic document report on my father's letter, the ink, the paper, the pressure deviation, the examiner, a woman named Dr. Constance Reed, who held faculty appointments at 2 universities and had been accepted as an expert in federal court on 19 occasions, had prepared a 40-page report. David walked through the summary methodically. He did not rush. He let every finding sit in the air before moving to the next one. When he finished, the courtroom was very quiet. Judge Osei looked at Sandra. He looked at Marcus. He looked at Burke. "Counselor," he said to Burke, Does your client wish to address the discrepancy between the notary's commission status and the execution date on this document? Burke asked for a brief recess to confer. The judge gave him 10 minutes. They did not come back from that recess with a counter-argument. They came back with a request to discuss settlement. I looked at David. He looked at me. I shook my head. I wanted the record. I wanted everything on the record. Judge Osei denied the document's admission to probate. He found the amendment invalid on the basis of defective notarization and referred the matter of Phil Greer's testimony to the Fulton County District Attorney's Office. He also noted, in language that I later read 4 times in the written order, that the financial transfers presented raised serious questions, warranting further investigation, and that he was referring those findings to the Georgia Secretary of State's office, which oversees business fraud and elder financial exploitation. He also ordered Sandra to produce complete financial records for Harlan Bridge Consulting within 30 days. Outside the courthouse, Marcus caught up to me on the steps. He didn't say much. He looked like someone who had believed, genuinely believed, that a well-funded attorney and a confident story would be enough. He had not understood that I had spent 8 months making sure it would not be. "You didn't have to do it this way," he said. "I thought about my father braiding my hair from YouTube tutorials. I thought about peach ice cream. I thought about a tie given as a Christmas gift being worn to undo a dead man's real wishes." "Yes," I said quietly, "I did." The original will was admitted to probate in full 6 weeks later. The charitable trust was restored. The youth apprenticeship program in Southwest Atlanta, the one my father had supported for 11 years, the one that had been quietly erased from the amendment, received its first distribution from the estate in April. Phil Greer reached a plea agreement with the DA's office in late spring. Sandra and Marcus's attorney negotiated a settlement on the financial fraud claims that I was advised not to detail publicly. But I will tell you that it was not nominal and that the terms included full cooperation with the Secretary of State's ongoing investigation. The bookkeeping service that Marcus had brought in lost its business license. I went back to work. I took 3 days off, the first real time off I had taken in almost a year, and I drove down to Savannah, where my father had taken me once when I was 8 years old, and we had eaten shrimp on a dock, and he had told me I could be anything I wanted as long as I was fair about it. I sat on a different dock this time, and I ate shrimp by myself, and I talked to him a little. I don't know if that does anything. I think it does something for me. Here's what I want you to take from this. If you're listening and you're in something that feels impossible right now, I had every reason to accept what Sandra and Marcus presented as a done thing. I was grieving. I was busy. They had money and lawyers and a story and the advantage of time. What I had was my training, my patience, and the understanding that documents don't lie, people do. But documents, when you know how to read them, tell you everything. I did not win because I was lucky. I won because I waited, I worked, and I did not show my hand until the moment it mattered most. My father built things for a living. He built them to last. I like to think he'd understand.